Good day, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk. Today we're here, and we're going to bring you what is commonly known here in the state of Colorado as the second advisement, the formal filing of charges as it relates to Barry Morphew. Now, it is being broadcast by the court. However, the court has issued orders that if you broadcast it, you will be held in contempt. So I'm going to just try to walk you through it because I don't want to be held in contempt. You know, I love you all, but I can't lose my law license, if you know what I'm saying. So anyway, I can tell you the scene from the courtroom is pretty straightforward. It's a smaller courtroom. Seated next to the jury box is the attorneys that are going to enter or have already officially entered. Drew Nielsen and Iris Itan for Mr. Morphew. Mr. Morphew has not been brought into the courtroom yet. The district attorney is on the other side of the courtroom. A couple observers in the background. I can't tell who those individuals are. But today should be rather uneventful, and I hate to, bring everybody down to on that. But there's not going to be a whole lot of excitement here today. More than likely, the court will ask the attorneys whether Mr. Morphew has received a copy of the amended complaint and information, which obviously he has because they will have given it to him, and they will have gone over the charges, and they will waive formal reading or advisement. Oh, looks like the court is beginning, and I guess can we listen in audio-wise? I guess we can't stream it, so I guess we...
Can you hear that?
Yeah. So we'll see.
We're missing somebody.
They realize that Mr. Morphew has not been brought into the courtroom yet.
This is Judge Murphy. I'm talking to you from the district courtroom in the Chaffee County Courthouse from Salida, Colorado. Case on the docket is 21 CR 78, People versus Barry Morphew. He is yet to enter the courtroom, so we will not...
Put him on? Yeah, I don't want to. Okay, yeah, we don't want to do that. Just unplug. Yeah. It's too short. Just
wait, one second. Too short?
all right. So the district attorney is appearing via WebEx, and Mr. Morphew has not been brought into the courtroom yet, and obviously they cannot start without him. The big issue today is whether the arrest affidavit is going to be released, because frankly, that's what I think most people are interested in. Normally, the second advisement, like I said, it's very straightforward. The court will ask whether the defendant has received a copy of the amended complaint and information, and whether they would waive formal reading or advisement of the charges. Oh, the court's admonishing everyone on WebEx. Okay, they're waiting for Mr. Morphew to arrive. Obviously, he's in custody. No bond has been set in his particular case. So, like I said, the court will acknowledge receipt of the amended complaint information, waive any formal reading or advisement of the charges. They will more than likely waive their right to a preliminary hearing. He has a right, Mr. Morphew has a right to a hearing within 35 days of today's date. But the defendant can always waive that right so that the defense team can get the discovery, review it, analyze it, figure out what they need to do. And they'll also set that in conjunction with a proof evident presumption great at that time. So Mr. Morphew has arrived. He is in an orange and white striped jumpsuit there in Chaffee County. Okay, here's the admonition. No recording or no rebroadcasting. And if anyone And if anyone does so, they could exclude you from future court proceedings. And you could be held in contempt. Okay, court's asking, says formal charges have been filed. As suspected, the defendant, through counsel, waived any further reading or advisement of the charges. Oh, now we're going to discuss some of the motions. Obviously, the big issue is going to be the issue regarding the affidavit for the arrest warrant. So the court is going to grant the release of all the search warrants, affidavits to the defense, but limiting that to the rest of the general public. His counsel, Barry Morphew's counsel, I'll go over this at the end, but it's Drew Nielsen and Iris Itan of Itan and Nielsen. I've known Drew Nielsen for 20 years. She's a great attorney. Iris Itan, I know her professionally, but have never done a case with her. Okay. Can you hear me?
You can't hear anything.
All right. Next is a motion regarding evidence in discovery, which is a preservation of so oftentimes the defense files a motion to preserve all evidence, make sure the detectives preserve all notes. Oftentimes detectives takes notes, then retype them and destroy the notes. You want all those notes preserved, no evidence tested or destroyed without the defense notice. Oh, they're going to go through each individual item, it appears. Let's listen here, see what I can give you. Like I said, the court won't let us rebroadcast this, and you'd be subject to contempt, and we don't want to do that. Okay. Court's going to say that no objection to preserving all recordings. It's a no-brainer. Of course, who's going to do that? The prosecution's objecting to all texts and emails between the detectives and prosecutors regarding this case. The argument is that it's overly burdensome to the prosecution. The prosecutor is saying that they communicate via text about information, and it'd be unduly burdensome to do so. Argument that's not required under the rules of discovery, and therefore they shouldn't have to turn those over. The defense attorney for Mr. Morphew, Ms. Itan, is arguing that these text messages are, in fact, witness statements. Ms. Itan is stating that these law enforcement officers, these are statements. There's no confidential communications between the district attorney and law enforcement, and all these witness statements need to be turned over, particularly if they exist. I mean, it's a reasonable argument. Maybe a little overly broad, but I understand where she's coming from. They're trying to get as much information as you can, particularly late in the course of the lengthy investigation, as it relates to Mr. Morphew, a little over a year. And the defense is saying, hey, there's an onus on the prosecution to do this, but it's their duty to do so, pursuant to Kyles v. Whitley, a 1995 United States Supreme Court case that says, hey, it's tough to be the prosecutor, but you have a duty to the defendant, so therefore preserve everything. I think the court will probably go with Ms. Itan's request. And this is one of the reasons why courts and defending clients is there's so much digital information available today, and you have to go seek it out, try to find it, seek it in discovery, but it takes time, both through investigators and attorneys, to do that. And so defendants arguing that there's no exception here under Rule 16 of the Constitution that would give the court's trying to clarify, what do you mean by pertaining to this case? Is it scheduling orders? Is it, hey, are you ready to meet for a meeting? That wouldn't necessarily be discoverable. I understand what the defense is arguing here. The judge may give her some of it, but not all of it. Obviously, if it's relating directly to this, would be fine. But the defense will have to spend that time, more than likely, having to go interview these witnesses. But here's a little dirty little secret. The police never, ever talk to defense attorneys. They just don't do it. I've had experts, but here's the court. The court's asking questions regarding text messages, regarding meeting to take a photo. They're scheduling a meeting. Is that what you want? Ms. Itan is arguing, yes, she wants everything is relevant and could be, and you just never know until you get it. And just because it's discoverable doesn't mean it's necessarily admissible. She's stating that is a witness statement under Rule 16. I like her argument, probably a little overly broad in her request. I think the judge will say if there's text messages regarding substantive conversations, that'll have to be produced. It's the thing about discovery. You just never know exactly what it is until you get it. And what a good defense attorney can do with it, you just never know. They may not know what road it will lead down. Ms. Itan's continuing to argue that police are going to be the primary witnesses in this case, and even if it's a scheduling issue, something as simple as scheduling could be relevant to her case. And she's talking about from the day this case started being investigated until the case is resolved. And that was in response to the court's question of how long. Now the district attorney wants to respond. The district attorney saying, hey, if you follow the defense attorney's logic, basically everything should be recorded, and therefore basically we have to turn over everything, even on scheduling orders, and that's just ridiculous. So I think the court gets the argument. Their position is that this will be in a formalized report, but I think the court may say that the court has to, and I'm sorry, I'm listening in here as well as trying to give you the lowdown on what's going on real time here, since we can't rebroadcast this. I think the court's going to split the baby, as they say. The court inquired whether any emails from the prosecutors would be included. Ms. Itan said, no, but we're asking those to be preserved. Obviously, what the prosecutors think would be work product and wouldn't be subject to disclosure, but they're arguing the defense is arguing that the questions or inquiries from the police officers to the prosecutors would be discoverable, which that would take a ton of time to produce, I'm sure. There were probably thousands of emails, and you had to redact all of those. And the court asked again, Kyles v. Whitley, which is a United States Supreme Court case. The court's going to punt on that one for right now. He'll defer later. He wants to read the case beforehand, which is smart, but it stands for the general proposition that the prosecution has to turn over, all exculpatory evidence. All right, now they're discussing the paragraph regarding all 911 calls, video statements, etc. I can't imagine the district attorney would object to this in any way. The district attorney is objecting to the request regarding any communication between consultants and experts. That's work product. I have to agree with the prosecutor on this one. I mean, I would love to know who the prosecutor was shopping there, if there's any experts around, and maybe somebody says, I can't do it, I'm not available, or it's this much money. I don't see how that's necessarily relevant. I would argue work product as a prosecutor. And the district attorney is acknowledging his duty to turn over any exculpatory information pursuant to Brady v. Maryland, which all district attorneys should know and be aware of. Ms. Itan is arguing that the names should be turned over. She's starting ABA standards, hardly binding on the court, but somewhat persuasive depending on which court you hear about. I don't think the court's going to allow that. what I find is very interesting is that there are people in the chat on the court's WebEx commenting like they're in a chat room on YouTube. I'm surprised the court would be allowing that whatsoever. He should probably kick anybody off who's doing that. I'm surprised the court is allowing that, given the admonition that the court made. Now, Ms. Itan is basically making her argument regarding the disclosure of that information and citing Kyles v. Whitley as well. And I understand the defense argument here for sure is when in doubt, produce it to the defense. But there's some things you just don't need to do as a prosecutor. The court's questioning her, saying, well, isn't that already covered under Rule 16 of the Rules of Criminal Procedure, that they have to turn everything over? And this is the problem. I mean, these are very experienced attorneys for the defense, but you don't want to appear as though you're overreaching and that you're going to just be a pain in the butt just to be a pain in the butt. They know what's required. If they think it's there, they know how to request it from the DA. Okay. The court is ruling that Rule 16 1A3 requires the prosecution to turn over any reports of experts that are prepared in this particular case, not the ones that they simply have ever contacted. Once again, if there's anything in their control that's exculpatory, the prosecution would have to do it. So it's already covered by the rule. Don't overreach, defense. Like I said, I'm very surprised the court is allowing these chats to go by on the court's WebEx site. People are literally chiming in like it is a YouTube channel. It's just not appropriate for people to be doing that. I think we're just about done with this motion, but there's a couple of objections. Now the issues being discussed is any testing that will take place. The district attorney is objecting to anything that's beyond the scope of Rule 16. And now the defense is saying we just want to be notified if there's any testing, particularly if it's destructive. That's routine. And the court just orders that if there's consumptive testing, then the defense would be notified. The DA agrees to that because that's in accordance with Colorado Revised Statute 16.3309. Now we're doing defense motion 6, which was a duplication of the motion that was filed by the public defender. And you have to understand, these are the motions that are filed early on, particularly in a homicide case, saying preserve everything, don't destroy everything. And not that the prosecutor's going to do that. They don't want to get in trouble. The prosecutors don't, but it's just a CYA thing so that you can say down the road, oh, I didn't get this. Look what they did. They were put on notice. So All right. They're preserving any biological samples and testing, which is similar to any DNA testing. And if there's consumptive testing, then the defense will have to be notified so that they can have their expert available. Standard, very routine. Okay, this is kind of another rehash of turnover all communications, including with the prosecutors, which is not going to be granted. It sounds like somebody maybe didn't. And the district attorney saying, hey, I will do whatever I have to do in accordance with the rules of discovery as well as any Colorado Revised statute. The court's inquiring whether there's anything specific. And now she's simply saying it's related to the preservation of documents, whereas the previous documents was to the production. Obviously, there's difference to preserve. We may be able to say, come up with a reason why it has to be produced later on. Okay. The court's going to wait on the previous motion issue that wasn't resolved. I'm a little surprised the court's taking these motions up today. We're at second advisement. The prosecution has to turn everything over anyway. I get it. It's a CYA motion to preserve and what have you. But this is the courts. Most courts usually just rule and say, provide what you have to provide under the rules. You get nothing else. Oh, geez. Now they're going to go through another motion because a lot of it's covered. What they're requesting is not covered by the rules. So now it looks like they're going to go through it paragraph by paragraph. Now, while they're doing this, Mr. Morphew is sitting in the jury box by himself in the orange and white jail suit with a blue mask on his face. He, other than maybe acknowledging his attorneys, there was no conversation between them. And frankly, he has nothing to say at this point. He just needs to sit down, shut up, and let his attorneys do their job. Okay, Miss Itan is now requesting tapes of interviews and notes that are not transcribed. Okay, that's not going to be required until today. The district attorney has said maintain notes, recordings of any type because it's a homicide case. So they have no objection to that. I'm not sure why we're going over this. The public defender had filed some general motions in this particular case to preserve. Now the new counsel's filed them, and there's appears to be some duplication. But the prosecution is not going to go out of their way to, get rid of the tapes. They have to save and preserve everything, whether it's good, bad, or ugly for the defendant, and they have to turn it over. Now they're on a subject regarding records and experiments. She's requesting medical records that may have been collected, cell phone records. That's all stuff that it's required to be preserved. I just don't know why we're spending time on this. To be honest with you, hey, it's great for us. We get to be live, and I can try to explain this to you since you can't, we can't broadcast this. But it seems to be they're just asking for what's already in the rules. It's just frustrating that we have to go through this. So, just now we're getting to prior convictions, adjudications of any witnesses. Once again, all standard information. I get you put it in the paperwork, you ask for it, but why we're going through this line by line, I'm not sure why the judge just doesn't grant these. But that's the way it is. Now we've turned a 5-minute hearing into a 30-minute hearing, and nothing of substance has been really conducted whatsoever.
Can we show a picture? Or no? Can we show a picture of it?
What's that?
Can we put a picture up?
I don't think so.
Okay.
That was Frank asking me if we could put a picture up, and the court's order, I think, would not allow us to do that. That would be in violation. Just like you can't take pictures in the courthouse, in the courtroom while the proceedings are going on. We can't do it here either. I wish we could. I wish we could just put this up on YouTube, but we can't. Once again, we seem to be going through a lot of the same information that's already covered in Rule 16. With a couple little nuances here. So what Rule 16 of the Colorado Rules of Criminal Procedure clearly outlines the prosecutor's obligations, police reports, transcripts, reports and statements of experts made in connection with a particular case, any books, papers, and documents, photographs held in connection, any record of prior criminal convictions, all tapes, transcripts, electronics information, a written list of all names of address and witnesses, any written recorded statements of the accused or co-defendant. The prosecutor's attorney shall disclose any material information within his or her possession or control which tends to negate the guilt of the accused as to the offense charged or would tend to reduce the punishment thereof. This is all stuff that's in Rule 16. Rule 16 is self-executing, which means that everybody has to comply with it. Then they go on prosecutors' performance of the obligation. It says that they shall perform their obligation under this section with regard to written recorded statements of the accused or a co-defendant as soon as practicable, but not less than 21 days after the defendant's first appearance. So the prosecution has an ongoing obligation to turn over all evidence that they have, police reports, tapes. Even if it doesn't help the prosecution, they can't destroy it. They have to turn it over. It's self-executing, and yet the defense has now filed motions basically cutting and pasting from Rule 16 saying that we want to make sure we have all this stuff. It's just kind of frustrating, I guess. And, maybe this is, I guess it's just best to be on the record, so to speak, where this can be done, but it's kind of unnecessary. Rule 16 also states what the prosecutor doesn't have to turn over, which is work product. It states in Rule 16E1, disclosure shall not be required of legal research or of records, correspondence, reports, or memoranda to the extent they contain the opinions, theories, or conclusions of the prosecuting attorney or members of his legal staff. Same thing would apply to the defense. You can't turn that over. If there were any informants in the case, that's the other thing, that they can withhold that basically until they basically have to testify. Now the defense is arguing that Kyles v. Whitley, that the prosecutor has a duty to learn of evidence maybe known to other prosecutors. Prosecutors often say, hey, if I have it, I will go get it, but I shouldn't have to go out and look for favorable information. But a lot of courts in the United States Supreme Court says, well, you can't ignore it either. You can't just say, hey, you have to inquire, is there anything else in the file that we don't have yet? So that's what the defense is arguing. Ms. Itan's arguing that there's an affirmative duty for the prosecutor to basically go out and ask. But you know what? That can be accomplished by simply sending an email. Go back and check your file. See if there's any information that you may have in your file that hasn't been turned over yet. And remind any police officer involved in this case that you have to turn over everything and we have to save everything. So, I mean, this is... The court is saying, hey, if the police have this information and the prosecutor becomes aware of it, he has an obligation to follow it and get it over with, or turn it over. But there's nothing that's going to say that he has to go out and investigate that. This is all Discovery 101. I don't know why we're spending so much time on it here. Now, if there's any medical records, of a witness, if it bears on their credibility, this is going to be promptly denied because it's beyond Rule 16. And the court just cut it off and said, you know what? Come back to me when there's actually an issue, which makes sense. Now, the judge in this particular case is Judge Patrick Morphew. Seems like an interesting gentleman. I don't think our paths have ever crossed, but his little bio states that he is a Colorado native, graduated from Denver East High School. He earned a degree in American history from the University of Pennsylvania and his law degree from the University of Colorado School of Law. Judge Morphew worked as a deputy state public defender for 20 years prior to his appointment as a district court judge. For 10 of those years, he headed the Salida Regional Office of the Colorado State Public Defender. Judge Morphew has lived and worked in the 11th Judicial District since 1995. And Judge Morphew serves as a chief judge for the district and hears cases primarily in Chaffee County, also known as Salida. That's the major city there. And so this is not the judge's first rodeo when it comes to this type of information. And that's really what it should be. Rule 16 is self-executing. Prosecution, turn everything over that you have to do. And if defense, you think there's an issue, you're not being turned over, then you need to come address it with the court. That's the best way to do it. As we sit here kind of going through paragraph by paragraph, line by line, it seems as though Mr. Morphew seems to be frustrated. So now the defense is saying that, hey, if they don't have the resources to record things, that the defense is willing to provide one if they're going to go out and conduct additional interviews. I'm not sure that's a request. Even the judge has just said, yeah, I think the sheriff department has the resources to get a tape recorder if necessary. So the defense is asking that all future interviews be recorded. The court's saying, hey, we have body cams, etc. The district attorney saying, hey, people have a right to object to be recorded. And so we'll see what the court decides here. And the district attorney is saying this is going to be overly burdensome. What do we call a witness to confirm a date that suddenly we have to record that? That's ridiculous. I'd have to agree with the prosecutor on that one. And this is the problem oftentimes with the defense, is that you can't appear as though you're overreaching. You shoot yourself in the foot when you overreach. And the judge is basically agreeing with what the prosecutor is saying here as well. So the court denied that request about recording all future statements by the district attorney's office or law enforcement for any reason. So yeah, it was denied. The next thing is they're asking for compliance with Rule 16. Duh. Of course, Rule 16 is always going to have to comply with. Even the court's saying, I think this is covered. Why are we requesting this? The defense's argument that the discovery hasn't been produced in accordance with Rule 16. The DAs are looking over like, are you kidding me? They're saying that Mr. Morphew appeared on May 6th, which is the 21st day. And then obviously, as I just read it to you, Rule 16 requires the discovery to be turned over in 21 days or within a reasonable time. It doesn't mean that you're going to somehow get the discovery taken away. So they're stating that they're 21 days out, and therefore discovery hasn't been turned over yet. Ms. Itan is saying that you've seen the affidavit, that the affidavit lays out rather clearly that the discovery hasn't been produced as of yet. The court's going to inquire of the prosecutor when the discovery will be turned over to the defense, but there's nothing unreasonably burdensome or delayed as to here. And listen, this guy was a public defender for 20 years. He gets it. He's sat at the defense table, and the prosecutor, I mean, the judge is just kind of looking like, give me a break. They're requesting the discovery be turned over tomorrow. It looks like the court may be shutting everything down here, or maybe closing stuff off. Or that's the court doing that, or us?
No, it's trying to put it in full screen, but I can't.
Oh. Okay. Anyway, well, the judge is just kind of looking there like, yeah, he actually took his glasses off when listening to our argument. Put him back on, and looks like he's going to rule. Here's the prosecutor going to respond. Yeah. The rule says first appearance or formal filing of charges. This is the formal filing of charges, which is today. I think the district attorney's right on this one again. So they're not in any violation, and like I said, okay, prosecutors stating there's about 10,000 pages of police reports, search warrants, as well as items of evidence have been seized during search warrants. The district attorney is also saying this involves several agencies, and they're trying to basically coordinate it, put it in some sort of order and organization for the discovery to not only help the prosecutor but the defense get through it as quickly as possible. And apparently the person that's primarily responsible for the discovery in this case is an employee that got sick, went home yesterday, and had not returned today. So I don't think that the judge is going to admonish the prosecution for not turning discovery over just as of yet. And I would agree the 21 days starts from formal filing of charges. The court wants to know, when can you get the hard drive to them? It sounds like the prosecution is renumbering the documents in some sort of PDF status so that and so they are the prosecutor's like, yeah, I'll have it to you by Wednesday. So the judge doesn't appear too offended, neither the defense. They're going to have somebody come pick it up. The DA wants to let the court, the defense attorney wants to know that Mr. Morphew is sitting in a cage in a jail, and they want the discovery sooner rather than later. I don't think the court, and so she's asking to be turned over on Wednesday. The judge had asked the prosecutor. He said he's going to do his best to get it there. There's now going to be a court order. So sounds like the prosecutor will be working over the weekend to get this done. The court's also reminded them that you're going to get access to the search warrants defense, and so you're going to have plenty to read through and go around. And the court did reiterate that he agrees with the prosecutor that the start of the 21 days is today, and that it has to be within reasonably practicable as written in the rule. And I get the defense attorney is trying to zealously advocate for their client, trying to look, Mr. Morphew, we're doing a great job for you. We're fighting for you. But you're not winning anything here that you are not already entitled to. So you really have to wonder what the purpose is. They're going to get the discovery by Wednesday. So it's a reasonable time. And the prosecution has a continuing and ongoing obligation to produce and turn over any new information that they receive. Discovery will be ongoing. So I think that everybody needs to just cool their jets. Okay, so here we are now into 50 minutes of usually what's literally a 5-minute hearing. Now they're requesting a list of chain of custody. Prosecutor says it's going to be turned over already, so what's the big deal? They filed a 16-3-309, which is basically stating that we need experts and the people that conduct any DNA testing to appear in court. That's by statute. Court granted it. That's a no-brainer. Now this is requesting that exhibit lists be turned over 45 days prior to trial, which is great, but we haven't even had a preliminary. We haven't got through the first motions hearing yet. Usually this is something that takes place down the road. No, the judge basically says that maybe we'll have a pretrial order so everybody knows what they're working with. The court says that we'll revisit the issue much later down the road. Defense is now asking that any exhibits that are going to be used at the proof evident presumption grade / preliminary hearing, that they be produced at least a week prior. The judge said that's fair. I totally agree. I got a homicide preliminary hearing tomorrow, and I got all the exhibits a week ahead of time. That's just fair. It's just good professionalism. So that's pretty standard. Okay, just exhibits. They're not going to provide physical evidence. The court saying that motion 8 is redundant. Judge is just making sure that there's no other further requests in the motion. But one thing that could be that's very good of this judge, like I said, I've never met with or come across him either as a public defender or a judge. But obviously he's prepared. He understands it's a high-profile case. People are to be watching it. It's always, great when the judge is the most prepared guy in the courtroom and is completely aware of all of the issues. Next motion is a standard motion. You file saying, hey, if there's revoke any waivers or releases of information, and that so that those everyone's put on notice of that. Okay, going to get some future hearing dates here. Okay. Court's going to be rather busy because of a backlog of cases since they haven't been conducting them for the last 14 months. There will be a joint preliminary hearing and proof evident presumption grade hearing. The defense has waived the 35-day rule, so there won't be a hearing within 35 days. Okay, so we have a date now. So we have so far 2 days set, August 9th and August 10th. Starting at 8 a.m., there will be a preliminary hearing. And if it continues, they'll go to August 23rd and August 24th. And that's simply because the court's schedule, and I'm sure calendars for all the attorneys make it difficult. So Mr. Morphew will not be getting a bond, at least until the end of the preliminary hearing. The next issue is regarding to the request of the next issue is in regards to the release of the affidavit for the arrest warrant. The court notes that any responses were due within the next 5 minutes. According to Rule 55.1 that just went into effect, there may be a hearing on it, or he can make his decisions based upon the pleadings. The court is simply just walking through the Rule 55 right now, 55.1, and state that if he's going to set a hearing, it's got to have public notice, so that, I mean, the news, the newspapers, things like that, they're the ones filing these requests to release. Now the next question is the (21 CR 85 case, which is the the 21 CR 85 case is the case regarding the voting issue. So in that particular case, he was given a PR bond. So on that case, he's probably not entitled to a preliminary hearing, but the statute is somewhat unclear. It says a person is in custody. but I think if they've given a PR bond, he's not entitled to the preliminary hearing in the case regarding voting for his deceased wife, Suzanne Morphew. I don't think the court's inclined to do that. That case should just trail. Frankly, it is the least of his concerns. He's charged with first-degree murder after deliberation, which means that, he will he's looking to spend the rest of his life in prison if he is convicted. I don't think he needs to worry about that. I don't think he needs to worry about the false information case. All right. So the proceedings from Chaffee County in Colorado, there in Salida, have just ended. It took over an hour, basically, from the time that the proceedings started. The defense went through a lot of the motions that were filed by both them, the new defense attorneys, Iris Itan and Drew Nielsen, both very, very good attorneys, as well as the motions that were filed by the previous counsel, which was the Office of the Public Defender, which is basically preserve everything. And really what the court did was say, hey, if it's in Rule 16, the prosecutor, you got to provide it. Don't destroy it, preserve it. And if there's going to be any testing, you got to give notice to the defense if it involves constructive testing. And I get it. And like I said, these are very, very talented attorneys in this particular case. But when you overreach and you try to get too much, and the defense didn't get anything that wasn't required under the rule, the judge is not going to go beyond the rule. And as the court said, you know what, a couple of these issues, we'll just wait until the very end, or as we get closer to trial, as the case progresses, to see if we even need to address it. It's not ripe yet, which is what basically the court said. It's not ripe. It's not an issue. There's not a controversy yet, so I don't have to decide anything, so I'm not going to. This, like I said, the judge in this particular case, Judge Patrick Murphy, he's the chief judge down there in the 11th District. He's a former public defender, so he's been, on the side with the defendant in the courtroom. He gets it, but he's a judge. He can't just go changing the rules because he wants to. It doesn't work that way. And so, that was it. We finally got around to a couple of dates. Preliminary hearing will begin on August 9th, continue through October 10th. If additional time is needed, it'll be August 23rd and August 24th. Now, I'm sure the defense would love to have a 4-day preliminary hearing. I can't imagine it's going to take 4 days, maybe 2. It may seem like good idea to set aside 4 days, which makes sense. Better to have it and not need it than need it and not have it. But the prosecutor is probably going to walk through the affidavit for the arrest warrant at the preliminary hearing with the officers, explaining why they believe Barry Morphew should be found guilty of this case if it went to a jury. And remember, at a preliminary hearing, the prosecution has to present some evidence that a reasonable person would believe that a crime was committed and that Mr. Morphew has something to do with it. Very low standard of proof, probable cause. The court must view the evidence in the light most favorable to the prosecution, drawing all inferences in their favor. All right. The next kind of combined hearing will be in regards to proof evident, presumption great. Is the proof evident, presumption great that Mr. Morphew was involved in it? If the court finds so, then that means involved in the death of Suzanne Morphew, I should say, to be more accurate. Then the court would issue a no bond hold. If the court basically says, hey, there's some evidence, I got to view the evidence in light most favorable, but this is not the strongest case I've ever seen, I'm going to grant a bond, then maybe Mr. Morphew will be able to get out if the bond is set. We'll all have to wait and see. We'll have a much better idea when and if the affidavit for the arrest warrant will be released. The court set 5 p.m. today. There were several responses the court noted from media organizations. And then pursuant to the rule, the Colorado Rules of Criminal Procedure 55.1, the court's going to make a decision basically weighing the public's right to know versus protecting the defendant's right to a fair and public, a trial, basically not being prejudiced by substantial news media. But the reality of it is, you know what? Yes, it's a small county. We can do this. You can move it. Once again, we've talked about this. You wait until you get to, if it's not just plainly obvious, you move it. If you can't select the jury, but you wait and see until you get the jury. So that's where we stand. I apologize. I wish we could have streamed it because it was on WebEx. However, the court issued orders saying, hey, we're going to stream it. Public has a right to know. We're still kind of COVID era type of stuff. However, don't stream it, don't record it, don't take pictures of it, or you'll be held in contempt. So I wish I could have done that for you today, but I don't want to go to jail. So I apologize. Better to be safe than sorry, because if I'm in jail, I can't bring you Crime Talk. And obviously that's the goal, is to bring you as much accurate information as possible, explain the law in straightforward terms so that everyone can understand what's going on. All right. Thanks for watching. Make sure you check out our video for today that we put up. Hopefully you enjoy it. A lot of breaking news out there as it's related to Lori Vallow, not competent. Take a look at the video. What does that mean? I explain it all. Go check it out. Have a wonderful day. We'll see you next time on Crime Talk.